Companies Act, Section 450, Punishment where no specific penalty or punishment is provided. Section 450 of the Companies Act, 2013 operates as a residual or default penalty clause, designed to ensure that every violation of the Act is enforceable. It reflects the principle that legal compliance under corporate law must be complete and continuous. No contravention, however small, should escape accountability simply because the Act has not expressly defined a penalty for that specific breach. This provision strengthens the regulatory regime by filling potential gaps in enforcement and preventing companies from taking advantage of technical or procedural loopholes. Applicability of Section 450. A company as a corporate entity, any officer in default, including directors, KMPs, and responsible managerial personnel, and any other person who is required to comply with relevant legal provisions. Section 450 is triggered when such persons violate any provision of the Companies Act, 2013. Any rule, regulation, or order issued under the Act. Any condition, restriction, limitation, direction, approval, consent, confirmation, recognition, or exemption granted by the central government, tribunal, registrar, or any other competent authority under the Act. However, this section applies only in cases where a specific penalty for the particular default is not already prescribed by another provision of the Act. Thus, the section acts as a catch-all safeguard to maintain legislative consistency and enforcement completeness. Ensures no violation goes unpunished. Ensure universal application of compliance obligations under the Companies Act. Prevent exploitation of missing or poorly drafted penalty clauses. Support better governance by discouraging even small or technical breaches. It ultimately creates a culture where compliance is the default expectation and negligence is not excused. Penalty structure under Section 450. The penalty mechanism under this section follows a proportional and escalating structure. Base penalty for initial violation. A fine of 10,000 rupees applicable on the company and on each officer person in default individually. Daily penalty for continuing default. An additional fine of 1,000 rupee per day after the first day of default. This continues until the violation is rectified. Maximum financial ceiling. 2 lakhs rupee maximum fine on the company. 50,000 rupee maximum fine on each officer or person in default. This ensures defaults are corrected quickly to avoid financial escalation. Penalties remain reasonable and proportionate to the gravity of the offense. Focus on timely correction of defaults. This section is designed not just to punish but also to encourage corrective action at the earliest possible stage. The daily fine structure puts pressure on companies to remedy the violation immediately. Discourages prolonged negligence or administrative delay. Makes continuous non-compliance financially burdensome. Thus, the underlying principle is correction over punishment. Promotes accountability and responsible management. This section reinforces individual accountability by penalizing not just the company, but also directors responsible for oversight, compliance and legal officers, any other designated individuals answerable under the Act. This ensures proper corporate governance systems are implemented. Officers exercise due diligence, care, and caution. Personal responsibility is taken for statutory obligations. Compulsory enforcement, no excuse for ignorance. Key compliance philosophy reflected under this section. Ignorance of law is not a valid defense. Even minor deviations carry enforceable consequences. Regulatory discipline must be continuous and consistent. The provision ensures that corporate governance obligations are mandatory, not optional. Nature of penalty. Section 450 imposes only monetary penalties. There is no imprisonment component. It is best suited for minor, technical, and administrative defaults, not severe offenses requiring criminal punishment. This makes enforcement fair and proportionate, avoiding excessive criminalization of trivial matters. Significance in strengthening corporate governance. Encourages companies to establish strong internal compliance controls. Protects stakeholders, investors, shareholders, creditors, and the public. Enhances reliability and credibility of corporate sector operations. Reduces ambiguity by ensuring all violations are covered. For more details, contact us.